You are about to see a piece of footage that has been watched over 50 million times. Analyzed frame by frame, slowed down, enhanced, debated. And after all of that, the most critical question it raises has never been officially answered. After this video, you will never look at a hotel security camera the same way again. Because what happened that night in Los Angeles was not just one tragedy. It was a symptom of a system, documented in court filings, insurance reports, and buried legislative records, that has allowed accountability to disappear into structural gaps that were never required to be filled. Let's start with the footage itself. You have seen this before. An elevator, fluorescent light flickering against pale walls. A young woman steps in. Then out. Then back in again. She presses buttons that don't seem to respond. She leans into the hallway, checking something just outside the frame. Her hands move in ways that, even after years of analysis, no one has been able to fully explain to everyone's satisfaction. And then the doors close. Most people who watch this footage focus on her movements, her expression, the way her eyes keep darting towards something we cannot see. But look somewhere else. Look at the timestamp at the bottom of the screen. There is a gap, 54 seconds, gone from the record. The official explanation from the Los Angeles Police Department was that it was a technical glitch, a malfunction, a glitch in what became the most analyzed piece of surveillance footage in internet history. Now, before we go further, let me be precise about something, because intellectual honesty matters here. I am not telling you that a glitch is impossible. Technical failures happen. Cameras fail. Files corrupt. What I am telling you is this. Peer-reviewed research in the field of digital forensics, published work, not forum speculation, has established that a genuine technical glitch and a deliberate edit leave very different fingerprints in the file structure. A real glitch, a power surge, a storage failure, typically leaves frozen frames, pixel scramble, visual static at the exact point of failure. A deliberate splice during export leaves something different, cleaner, seamless, sometimes accompanied by a subtle frame rate shift right at the cut point. These two signatures look completely different under forensic analysis. The distinction is documented methodology, not opinion. And here is what independent investigators and documentary journalists have been stating on the public record for years. The LAPD declined multiple formally documented requests to release the complete, unedited footage for independent forensic review. That is not a theory. That is in the public record. If it was just a glitch, why not release the full footage and prove it? That question has never received a public answer. And that silence points to something structural, something that goes far beyond one case in one hotel. Before we go further, I want to ask you something directly. Do you think the 54-second gap was a genuine malfunction, or was it something else? Answer in the comments. I read every single one. For a moment, set aside the mystery entirely. Instead, put on the hat of a risk analyst at a major hotel corporation. Because what I am about to walk you through is not theory. It is documented in legal filings, insurance industry reports, and peer-reviewed academic research on hospitality liability law. Hotels are what the law calls premises liability holders. Under U.S. tort law, if something happens on their property, they can be held legally responsible if negligence can be proven. And negligence in court is almost always proven through evidence. Surveillance footage is evidence. Now, here is where the incentive structure becomes worth examining very closely. A comprehensive security system overhaul for a mid-size hotel, according to Security Industry Trade Association estimates, runs between $1 and $3 million. The average out-of-court settlement in a premises liability case where footage is unavailable? According to analyses of resolved hospitality cases in legal databases, settlements are significantly lower in cases where footage cannot establish negligence than in cases where it can. You do not have to believe in any particular theory to understand what that math means. You just have to understand incentives. If the footage survives, liability becomes provable, quantifiable, potentially very costly. If the footage is gone, it becomes a tragedy, an accident, a technical failure. No clear accountability trail. No headline that ends a brand. Here's the data point that should make you sit up. A 2021 University Law Review analysis covering a decade of hospitality premises liability cases found that in approximately 1 in 5 cases involving serious harm at budget and mid-range hotel properties, surveillance footage was unavailable, corrupted, or claimed to have been overwritten. 1 in 5. Now compare that to casinos, where footage retention is federally mandated and subject to Gaming Commission oversight, or banks, or airports. In those environments, footage loss in liability-relevant situations is statistically near zero. Not because the technology is different, because the legal requirement is different. Hotels, in most U.S. states, have no mandatory minimum retention period for surveillance footage. None. In 2024, California legislators introduced Assembly Bill 2847. The proposal was specific, it was modest, it was reasonable. Any licensed lodging facility must retain high-definition surveillance footage for a minimum of 30 days. Failure to comply would result in financial penalties scaled to property revenue. It was the most direct attempt to address hotel footage retention in the state's legislative history. It never made it out of committee. The hotel industry's primary trade association submitted formal opposition. Their public arguments centered on 2 concerns: guest privacy and operational costs. And to be fair, both of those are real considerations. Legitimate privacy questions around long-term footage retention do exist. Storage costs are real. But investigative reporters examining the public record found additional context worth noting. Among the concerns documented in formal regulatory submissions and public testimony, which are matters of public record, industry representatives raised questions about the impact on insurance liability calculations. Specifically, the concern that standardized footage retention requirements would give insurers a more precise evidentiary basis for pricing premises liability coverage. The estimated industry-wide impact of more accurate liability pricing was cited as a significant cost factor. To be clear, raising insurance cost concerns in regulatory proceedings is entirely standard practice. It is not inherently evidence of bad faith. What it does tell us on the public record is that the financial consequences of accountability were part of the calculus. Not just privacy, not just storage, the economics of being held responsible. The bill died. The cameras stayed unregulated, and the gap between what hotels are legally required to preserve and what legal advocates say victims' families actually need remained exactly as wide as it was before. I want to step back from the statistics for a moment, because it is easy for a video like this to stay abstract. Numbers, legislation, forensic terminology. But there are families, parents who received a phone call and booked a flight, spouses who hired attorneys and filed motions, people who formally requested, through proper legal channels, the footage that should have shown what happened to the person they loved, and were told it does not exist anymore. In documented civil suit filings, public record, verifiable, the explanations vary. Hardware failure, routine overwrite cycles, coverage gaps in camera placement that left key corridors unrecorded by design. In 2023, a coalition of legal advocates and victim rights organizations formally petitioned the American Hotel and Lodging Association to adopt voluntary industry standards for footage retention and camera coverage minimums. They received an acknowledgement letter. No policy followed. Elisa Lam's case is widely known because the footage that does exist is deeply unsettling because tens of millions of people watched it, because the questions it raises never fully resolved. But there are cases less covered, no viral footage, no widespread online discussion, where families are left with even less, where the legal system without footage has very few tools remaining, where the only explanation anyone ever gave them was technical glitch. There is also this. In 2023, a cybersecurity firm published a formal report identifying active vulnerabilities in hotel-deployed IP camera systems across properties in 14 U.S. states. The report was submitted to the relevant manufacturers. Some patches were issued. Others remain, as of this year, listed as open in public vulnerability tracking databases. The gap is not just regulatory. In some documented cases, it may be technical and currently unresolved. Elisa Lam's case was officially closed. The timestamp gap was officially a technical anomaly. The security records from that night are officially unavailable for independent review. Everything is official. Nothing is fully explained. And here is where this stops being a story about one hotel in Los Angeles and becomes something that directly concerns you. Every night, in hotels across this country, cameras record footage that will never be reviewed. Hard drives cycle on automated schedules. Systems overwrite themselves by default. And if something happens to you or to someone you care about, the record of those hours may simply not exist. Not always because a system failed, sometimes because no law ever required it to succeed. This is not unsolvable. The research has been done. The legislation has been written. The advocacy organizations exist, and they are still fighting. The National Crime Victim Law Institute among them, for federal minimum standards on surveillance retention in lodging facilities. What is missing is enough public awareness to make the regulatory conversation impossible to ignore. I genuinely want to know your answer. Do you think hotels should be legally required to retain surveillance footage for at least 30 days? Leave it in the comments, because the families who were handed a server error report instead of an answer deserve more people asking this question out loud. Next time you walk into a hotel lobby, look up at the cameras above the front desk, then find the spaces between them. That is where the accountability went, into the gaps that were never required to be filled. Don't miss out on the next content. Subscribe, like, and turn on notifications.